Hello, this is Jonathan Gadir, and welcome to another episode of Loose Cannon, the Civil Liberties podcast. And I'm joined, as always, by my esteemed co-host, Parnell McGuinness. Hi, Parnell.
Hello.
So, states and territories across Australia have relied on emergency laws to manage the pandemic, and these laws have given government health officials broad and supposedly temporary powers. And as listeners to this podcast probably know, the Victorian government is now embroiled in a political battle to get its new pandemic response bill through the upper house in Victoria, with a vote expected next week. I've been a little disappointed by the responses from some organisations that are defenders of human rights and civil liberties. They've been very, very polite. On the other hand, you have Victorian Bar Association saying the bill authorises, quote, virtually unlimited interference, unquote, with the liberties of Victorians. They've pointed out that once a pandemic declaration is made, the health minister can make any order, and that power to make any order is not constrained by much, except by the minister's subjective belief that the order's reasonably necessary to protect public health. So I think it's really good that we've got someone who's across the action joining us today. That person is William Partlett, Associate Professor at Melbourne Law School, and he's been publicising what's in the bill and educating us in various media articles. Glad to have you here, Will.
Yeah, good to be with you guys.
So, Will, you've written there are 6 things that we really need to focus on to make this bill better. Did you want to maybe go through them and we can tease out what are the issues?
Yeah, for sure. I mean, let me start out by saying that, I think the response of some groups to this law has been somewhat confused, because in some ways this process is actually a really important process. And it's an important process because the context is that in every state and territory in Australia, essentially the old state of emergency laws and the Public Health Acts provide pretty much unlimited power to the executive in the event of a public health emergency. Now, that is why is that the case? Because generally public health emergencies and the state of emergencies, we're thinking of, some form of salmonella poisoning or a bushfire or something like that, a short-term emergency. So really the states have, there's been very little focus on these laws. There's been, and it's largely just been, okay, well, in a time of short-term emergency, we need pretty much, we don't need to worry too much about procedures and checks and balances and so forth. So anyway, so the first thing to point out is that what is happening in Victoria is actually positive. Like, we vitally need a pandemic fit for purpose law in Victoria. New South Wales needs one. Every state in Australia needs one that will actually bring in checks and balances and bring in transparency and help us kind of focus and cope with a lot of the issues that we're currently facing and that we've learned, right? Because we now know that pandemics can last for years and years and years. No one knows when this one's going to end. And as a result, we desperately need to think about how, and particularly at the state level, and this is something that I think is really interesting about this, is we normally focus a lot of our scrutiny on the Commonwealth and what the Commonwealth is doing and so forth and so on. But in the last 2 years in Australia, and this is not just Australia, it's other parts of the world as well, power has shifted to the subnational level. And in Australia, it's been the states. Obviously, we all know who our premier is. If you live in Victoria, you definitely know who Dan Andrews is, and you know who the chief health officer is, and you know who the health minister is. And you probably wouldn't have. A lot of people wouldn't have known that information, 1-2 years ago. So we really need to be focusing on these state level laws. And this is a conversation that is actually relatively new. Not a lot of scrutiny has been placed on the states and on how states operate. And so that's really the context for this bill. Unfortunately, for a number of reasons, this bill has had to be fast-tracked, which has closed a lot of the abilities for individuals to consult and on such an important bill. But the reality is the Victorian government needs to get basically before the 15th of December a bill through so that it will be able to keep some of its COVID settings in place. So as we're going forward, and we've still got a couple weeks, and and the debate goes on in this week and next week, there are these 6 things that we think that could make the bill even better. And I'll go through them quite quickly, and then we can kind of pick up on them. I think one of the most important ones is Parliament needs to be in the game. We need to bring Parliament into the scrutiny of executive pandemic management. This has been a problem in every state, not just in Victoria, but it's been a problem in Tasmania. It's been a problem in New South Wales. It's been a problem in many states where Parliament, and particularly the upper houses, have struggled to review, to look at, to scrutinize the large use of what we call delegated legislation, right? Essentially decree orders issued by the health minister in many cases, or by the chief health officer, depending on the state regime. That we need to bring Parliament into a form of review of this. And so one of the things that we suggest is bringing in a specialized cross-party oversight regime, where you have a specialized committee that can oversee this process. And the leader of this, crucially, is not a leader of the government, is not a member of the government. Is actually the leader is either a crossbencher or a member of the opposition. And the government does not have all the numbers. The government has representation on this committee, but it wouldn't have the majority. So that this institution can actually provide real oversight. So it can call witnesses. It can ask for documents. It can issue reports. It can make non-binding recommendations and so forth. But this is important, and we've seen this develop in New Zealand. We've seen it develop actually at the Commonwealth level. There's this what's called the Senate Select Committee on COVID-19. So that's just one example of where we say Parliament should get more involved. We also have talked about bolstering this, what's called the Independent Oversight Committee. At the moment in the proposed bill, this expert committee is fully appointed by the health minister, and we think that that's a problem. It should be appointed. I mean, there should be independent. Maybe the Doherty Institute should be able to appoint one representative. Maybe the Law Institute of Victoria should be able to appoint someone. Give some of these appointments and these experts to be appointed to particular bodies or stakeholders in Victorian society. We also think that there needs to be a review mechanism for detention. There is quite strong detention powers given not just to police, but also to authorized officers in this bill. Obviously detention is sometimes needed to quarantine individuals and so forth, but we want to make sure that this is actually done with some independent merits review. We also want to see particularly some proviso in there for safe protest. And we can talk more about that as well. During the last lockdown, there was a convoy protest, for instance, with around a refugee hotel in Victoria, where everyone was following the health advice, but they were in a convoy of cars, and they were all fined for protesting. So we're thinking about, if you can protest in an epidemiologically safe way, that should be seen as a reason to leave even during a hard lockdown. If you're wearing a mask, if you're exercising, you're in your car doing something like that, that it doesn't pose any threat to the society at all. And finally, the last one is we think that there needs to be some sort of sunset review. Actually, interestingly, if you look at the UK has a specialized fit for purpose pandemic law, but it says within 2 years it's going to be sunset. It goes out of effect, and it needs to be kind of revisited. So because we're kind of building the ship as we're going at the moment. We'll know a lot more in 2 years. And failing that, we ask for some sort of robust review. At the moment, the bill has a very weak kind of review process built into it. So those are some of the ways I think that the bill could be improved. And if I think, if these can be added into the bill, I think it actually will become a model for other states in Australia in developing their pandemic laws.
Okay, before we get into it, I think there was one bit you skipped over, which was the measures targeted at specific groups. There's some override of discrimination laws, and I think that's caused a lot of community concern.
They've changed that in the amendments. So the amendments they introduced last Monday, they've changed that.
Right. Okay. So what it said before was we can apply pandemic response measures to different people.
Attributes, based on attributes, including political belief, religion, race. Yeah, that's what it said before. It now the government has agreed to change that legislation. Yeah, that language.
Yeah, Parnell, I know you've got some issues to ask Will about in respect of experts and expert committees.
Yeah, look, well, one of the things that has occurred to me in looking at this is, first of all, I feel quite allergic towards the very concept of experts after the past couple of years, because I feel like experts and expertise has been used in quite a political way sometimes to keep us locked down, or, to impose a certain risk profile on society, which I feel might not have had such a prescriptive risk profile. But I'm actually going to ask the question a different way. Listening to you just now, it occurs to me, is this more or less what Sweden had? This sort of expert committee which weighed up the pros and cons of locking down, and on balance decided not to, and therefore kept Sweden open, which has proven now to be a very controversial decision. What are your thoughts on that?
Well, the first thing to say is that the expert committee that is created in this bill has absolutely no power. It is purely a recommendatory body. It is there to, so the minister, as it currently states, the minister can consult. The minister can ask for advice from individual experts on the committee. The minister does not have to take any of that advice. The minister obviously is appointing all of these individuals, and the minister is setting the terms and conditions of these experts as well. So presumably, I mean, it doesn't state in the law, but the minister, I presume, could relieve individuals of service on this committee. So the committee is really quite weak.
How is that different to what has existed to date? Because my understanding was that experts have in fact been making recommendations to government, but it's the government that has chosen to hide behind, or to use the term, we're just following the expert advice.
Yeah, so I mean that's one of the big changes the pandemic bill makes, is it moves from a technocratic model. So formally, all of the orders that were signed in Victoria were signed by Sutton, the chief health officer, or someone he delegated that power to. It was, and under the Public Health and Wellbeing Act, those powers all were essentially adhered in Sutton, in the chief health officer. So it was a highly technocratic approach. Now, what's interesting, as anyone who's lived in Victoria in the last 2 years remembers, is that we saw some of Sutton on television, but we saw a lot more of Dan Andrews, the premier, obviously. And, so there was some question of what was the interaction between the two of them with respect to those decisions. And as a result, I think the decision was made with this new proposed pandemic bill, which is currently obviously sitting in Parliament, is to switch to a political model, which is, so now the power goes to the premier to make a pandemic declaration, and then the health minister issues the orders, and the health minister can consider what the chief health officer has said, but doesn't have to, and can take into account a number of other factors. So it's really a kind of political model that's been brought in the current proposed pandemic bill that we have sitting right now in Victorian Parliament.
How does that aspect compare to everywhere else? Like, I know we're focused on Victoria, but is it better or worse or the same as the other states and territories?
Actually, well, yeah. So I mean, there's been a lot of talk in Victoria about how this is essentially the New South Wales approach. So the Public Health Act in New South Wales gives full power to the health minister, Brad Hazzard, to issue the pandemic orders, basically. And so as a result, there's been a lot of talk about how Victoria has taken the New South Wales approach. What's interesting is that the rest of the other states, Tasmania, South Australia, WA, Queensland, and so forth, they all lodge the power in the chief health officer. So it's I think, I mean, my view is generally, given, I know you guys had quite an interesting discussion with Sasha in the last podcast about this, but that, the health advice doesn't necessarily track perfectly onto what the lockdown settings exactly look like. So it's probably more honest to give this final decision making about the actual parameters of the lockdown or the parameters of the COVID settings to a political minister, whether it's the premier or the health minister, who's responsible to Parliament. So my sense is that like that's a good change in the Victorian approach. It's just that, as we point out in that piece, and I think a number of other people have pointed this out as well, if you're going to turn this into a political process of decision making, you need to give Parliament real scrutiny powers to oversee the exercise of that power, right? Because it's a political power.
Right, and that is more or less what happened in New South Wales, as the email trail between Kerry Chant and the Premier sort of revealed recently, that showed that Chant had in fact advised that all of Greater Sydney be locked down equally. So the places which had a high outbreak, as well as places with less transmission. And the Premier then made the decision not to lock down the areas with less transmission, which makes me think, of course, the one thing that isn't allowed for in expert testimony or expert advice is the politics of the expert themselves. So Kerry Chant, perhaps admirably, has a very strong focus on equity and equality. And so she feels that every health measure should be targeted towards equity. And so she thought all of Greater Sydney should be locked down. The Premier made the decision then, no, we're just going to apply the health advice to where there is a health problem. So there is a sort of ironic switch around in this that I just wanted to sort of add for listeners' benefit there.
Yeah, precisely. I mean, I think so. So the Victorian bill will move Victoria in that direction towards saying ultimately that the health minister, in making pandemic orders, will be able to, as in New South Wales, take into account a number of different factors beyond just, obviously there will be a very strong reliance on that, and you'd hope there's a very strong reliance on the health advice, but of course the health advice doesn't track on to the settings 100%. So yeah, they take into advice other things, and that's then subject to debate and deliberation and parliamentary oversight and scrutiny, whether through questioning in question time or through a specialized committee.
Ask about the detention part of it. How does it compare with what we have in other states and territories?
Well, again, the Victorian one is much more extensive. This bill is 117 pages long. Most public health acts in other states are very short, right? And in fact, if you look at New South Wales, for instance, it spends a lot of time talking about, I think, salmonella outbreaks or poison water. So there's a lot of stuff that there's really just not a lot of discussion of quarantine or detention in the other states' health acts at all. Whereas in this one, there is a lot. And of course, that makes sense. We know that, after the last 2 years, we know that one of the key ways to control kind of infection in a pandemic is to basically keep people in one place, right? Deprive them of their right to movement. And this bill calls that detention. Now, it's interesting why they called it that. I'm not quite sure. But anyways, they call it detention, and it's very extensive. It gives detention powers to authorized officers who already had that power under the pre-existing act, but now it gives the authorized officers powers to detain classes of individuals as well. So there's pretty significant detention powers here that can be renewed on a 24-hour basis. And in many ways, I think the legal community doesn't really suggest. We don't think that these detention powers are problematic. We just want to be ensured that they're exercised with some form of independence, merits review, scrutiny beyond what's created in the current act. The proposed bill at the moment provides for what's called a detention review officer. These detention review officers are meant to be, they're actually lawyers. They have to be lawyers for 10 years, but the detention review officer is also subject to an order from the health minister. The health minister can order them to do certain things, as well as, and then if the detention review officer suggests that individual detention should end, then a recommendation is made to the chief health officer, who's at the final word. So again, this internal executive process, I think most people who've looked at it have thought it's actually not sufficient and not a sufficient safeguard on the pretty broad executive detention powers that currently exist.
I'm not really comfortable with detention as a word. Maybe it just means what it says. Maybe they actually want a detention power rather than a sort of vague, watery, um, stay at home order type of power.
Yeah, I mean, look, I think it's meant for, if someone if someone is infectious and they're refusing to stay at home, I think that's when they say, okay, well, that's when they want to use the idea of detention. I presume that's what they're talking about. It remains to be seen, but I mean, however they exercise this power, it needs to be exercised with a level of scrutiny, and scrutiny that is not an internal executive process controlled by the health minister, but by an independent body. Whether there's a number of different ways in which that could be done. VCAT could do that in the Victorian context. You could appoint individual, specialized magistrate to do this. There's different ways in which expedited independent review could happen, but it certainly needs to be overseen.
Do you think this would fly in the US or in Canada?
Well, it's very hard to say, depending on where you are. I mean, of course, the US is extremely pluralistic and different depending on which parts of the US you're in, or in Canada as well. But these broad detention powers, I think they, if they are necessary, they need to be exercised with oversight. I think that's the bare minimum I think we need.
On that, so I just, noting your sort of very interesting scholarly background, including studying Eastern Europe and the Soviet bloc, I thought it might be an interesting question to ask you, Will. Are there for you, in the way that this is formulated, any red flags? So, obviously, I don't expect Australia or Victoria to turn into a totalitarian state anytime soon, but I would be really interested to hear your thoughts on what are the sort of things that worry you when you look at bills like this? What are the sort of things that ring a bell and make you think, this is where those regimes started to push through greater controls of their populations?
Yeah, so I mean, I guess the first thing to say is, I study those regions. I'm also a historian, so I've got historical training. So the first thing to say is, obviously the former Soviet republics have a very, very different history than Australia does. So that's the first thing to say. And so as a result, it's very difficult to make comparisons on that ground. Now, what I will say that does worry me, and I've written about in different contexts, is one of the things that you see from, at least from studying the parts of the world, the former Soviet republics, is what is a understanding of importance of structures and importance of relationships between institutions. Whether that be the relationship in the Australian context between the government and Parliament, or the relationship between the government and the courts. So one of the things that I find really interesting, and I think that's really drawn me to this pandemic bill, is this pandemic bill is what in the UK they would call a constitutional statute. It sets up a regime whereby it creates a special set of relationships between our kind of institutions and separations of powers that that potentially can last for a long period of time, right? The Premier, under the current proposed Victorian law, can issue a pandemic declaration for 3 months at a time and can continually do that indefinitely. So we need to kind of think about what's the relationship between institutions in this setup that the pandemic bill creates. And one of the things that concerns me is, of course, that Australia has, as well as Victoria, a very, very deep history of parliamentary democracy, and Parliament is the key institution. And the concern that I have, and many others have, about this, and you've seen this, I think, very much in what the Victorian Bar said, the Law Institute of Victoria, the Victorian Ombudsman, Deborah Glass, and others, is a concern that this pandemic bill is not actually addressing the problem that we have, that we face, and that we've seen over the last 2 years, which is pandemic management has been operating under these pre-existing laws that essentially allow for full-scale executive governance, right? With very little scrutiny from courts and very little scrutiny from Parliament. And that's something we should be concerned about. Everyone in Australia should be concerned about. And, the concern we have about this Victorian pandemic law is we're saying, okay, here's a fit for purpose law, and it's not fixing the problem, right? It's in some ways, it's keeping that existing problem from the last 2 years in place. So that's the concern. And that problem is, of course, that there still remains not sufficient oversight particularly from Parliament. And it doesn't pick up this emerging practice that I mentioned before, whereby parliaments are bringing, the members of the opposition and the crossbench into a general oversight committee type situation. And, in the classic example of this now is the work that actually, interestingly, the Labour Party, Katie Gallagher, is doing at the Commonwealth level. The Senate Select Committee on COVID-19 is doing a fantastic job of oversight over what the Morrison government is doing. And I think it's kind of ironic that now at the state level, the Labour government here in Victoria, the Andrews government has not put this in, because of course at the national level, that's their key proposal. They want more parliamentary oversight of Morrison. So, I think the emerging practice here is we need to be thinking about how to get Parliament back into these games. So we don't have essentially executive managerialism, right? Where we just have the executive saying, well, I want to keep people safe without and basically dodging or avoiding scrutiny. And that we've seen that happen at all levels of government in Australia. We've seen that happen all over the world, to be honest. And I think it's an important project of this pandemic bill. And we hope in the next week or so, we're going to see a bill that actually brings in some more checks and balances. Because of course, that's the center of our pandemic management going forward, is we've learned that, executives like power, they don't like oversight, they don't like checks and balances. And it's important now for us to begin to figure out how we can do that in a way that is appropriate.
Do you think a Human Rights Act or Human Rights Charter makes any difference? Because we've had guests on like James Allen who have said there's no difference to when the rubber hits the road, judges don't actually check government power. And we've seen that in the pandemic when people have challenged the curfew, for example, they've just deferred to the government. Do you think the presence or absence of a Human Rights Act or human rights protections in the Constitution makes any difference?
Look, I think it makes a difference, yes. How much of a difference it makes at the height of a pandemic? I think, everywhere in the world, courts are unwilling to really step in and actually invalidate actions taken by governments, by executives at the height of a pandemic. We've seen that everywhere. You see that everywhere during wartime. One of the most activist courts in the world, the U.S. Supreme Court, essentially backed off and allowed essentially Roosevelt to detain Japanese Americans. So, courts generally are not very effective checks on executive power in times of emergency. And this is another reason why, I think a lot of us, and, I'm a strong part of this, think that we really need to be thinking about parliamentary checks, right? Parliament and ensuring that political deliberation continues during pandemics and political discussion. And that's done in a way where it's not, that Parliament doesn't get in and start actually disallowing huge numbers of orders, but actually starts to scrutinize and say, well, take one example, the tower lockdowns in July of 2020 in Victoria. Parliamentary scrutiny step in immediately afterwards and say, what happened? Was notice given? What were the issues? Bring in witnesses, issue reports, talk to media. Like this kind of thing is important, I think, so that the government knows that there is scrutiny, there is oversight. It might not be, real time scrutiny, but I generally think that that's the kind of cut way in which we can get checks and balances in. I just don't think courts and human rights charters and so forth are going to be particularly effective in times of real pandemic emergency.
Right.
So we've got a new Human Rights Commissioner who's just started up, Lorraine Findlay, and she has sort of stated that her focus for her term of 5 years is going to be rights and freedoms in particular. If you had an agenda that you could give her around this, what would it be?
Yeah, I think it would be looking at emerging, this sounds like really overly kind of technocratic itself, but best practices or ways in which parliaments are around the world are developing ways of scrutinizing the ways in which executives operate. So in the Australian context, I think a really interesting, and this is a line of research that I'm pursuing with members of the Center for Public Integrity, is looking at the way in which the upper house, the role of the upper house in Australian parliamentary democracy, the role that they can have, because of course upper houses, in most cases, the upper house is not controlled by the government. In many cases, that there are crossbenchers or independent members of parliament who have to sign off on pieces of legislation and so forth. Those crossbenchers can play a really important role, not just in negotiating laws, but also in oversight. And we can see that, I think, play out quite well. I mean, New South Wales is a really interesting example. One of the New South Wales cross-party parliamentary oversight committee is actually headed up by a member of the Greens party, and it's done a fantastic job of looking, of scrutinizing and so forth. So I think, crossbenchers, small parties, independents, I think we can look at that, and that's a different model of rights protection, right? It's not one that's just focused on courts. Now we do want to think about courts, and we want to look at proportionality and so forth and so on, and how proportionality operates in a pandemic is a really interesting question. But I do think we want to be looking at political models of rights protection as well, because I think it's, in some ways, I mean, and this is something that a number of people have been writing about, the current model of parliamentary scrutiny is kind of failing, and this is not a pandemic story. It existed pre-pandemic. It's that governments were saying, well, look, we're government's increasingly operating through delegated legislation, right, through executive orders and so forth, and either not tabling them or essentially exempting them from all forms of scrutiny. So, this is, and it's a trend that's really picked up during the pandemic. And I think I'd say I would hope that would be one of the things that would be looked at quite closely, is how can we revitalize the role of the upper houses in this kind of scrutiny to get real forms of political rights protection, right? And that's a deliberative model. It's a dialogue model. It's one that's much more consistent with the Australia's kind of rejection of a constitutional Bill of Rights and so forth. It's much more consistent with Australian history and distrust of unelected judges and giving them all that power. So but if you're not going to give that power to judges, then let's ensure that politics and deliberation and discussion and transparency in debate essentially do this, because I think one of the things that has kept and played an important role in many, and probably not as important roles as it should, but is been discussion in media and so forth. I think that's been one of the areas that has been probably the strongest check on the power of many premiers across Australia in the exercise of these powers. So I think a way to do that is to say, how can we build on that and build a better form of parliamentary scrutiny? I think that would be a really important area to look into.
I'm interested in whether you think the community opposition, the community backlash is understandable, reasonable, justified. Is it something that's related, do you think, to specifically what Victorians have been through in the past year and a half? There's been a lot of snobby kind of dismissing of the demonstrations in particular. Tell me a bit about your feelings on those.
Yeah, I mean, I think there are a number of different reasons people have taken to the streets to protest. I think, it's very clear some people are there for really, really nasty reasons, right? They're there to threaten individuals, threaten members of the crossbench. They're there to bring out really nasty kind of Nazi imagery and so forth. I don't think, I tend to agree that there's been a lot of focus on that, which is unfortunate. I mean, I think that it's a minority of people, but they're certainly there, and that's concerning. Those people are concerning. I think there are a lot of people there as well who are opposed to the vaccination mandates that have been put into place. I do know that those are people from all sides of politics. I mean, I know that I have personally know an individual who's a member of the Greens who is who's opposed to vaccination mandates and has been at some of the protests. So look, I think and then there are people who are there because they don't like lockdowns, because they're still very frustrated about a lot of what happened. They lost their jobs and so forth. So there's just the general frustration. Of course, for anyone who's in Melbourne, we've been sitting in some form of lockdown for 270 days. It's a long time. I think people are, so that, the timing has been, the timing is not great really for sensible discussion. And I do think there are also some people there who have some concerns about just wanting to get the balance right here. I do think that's the case. And certainly that's the case amongst a lot of the legal groups that have participated in the discussion as well. Is this is an opportunity. Maybe it's a little bit more condensed than we would have liked, but it's an opportunity to try to find a better balance between manage health management, and obviously the importance of protecting public health, but also there are ways in which we can continue to protect public health with scrutiny. How do we do that? That's a discussion we need to have, so we can lead to the same outcomes, right? I mean, it's been Australia's had a very successful response to COVID in comparison with most of the rest of the world, but that doesn't mean that we can't learn from this and try to figure out some additional ways to build in. And of course Victoria has had some of the longest. We have the most experience with this because we've had the most strict and longest set of COVID restrictions. So in a way, it's like it kind of makes sense that Victoria is where this debate is starting. And again, I go back to what I said before. I really do hope that they get the right, that we get a good bill here, because I think it will shape the discussion in the other states going forward. I know that already in New South Wales, people I know in the legal community are already talking about the importance of really figuring out something next year for New South Wales, because the New South Wales Public Health Act is essentially unlimited executive power. So it's time for, I think it is time for all the states to and hopefully Victoria can really provide a model for that. But of course that's, we'll see how that goes. I mean, that's what we're going to find out in the next couple of weeks, I guess.
Yeah. I'm just very suspicious about reasonable, so-called reasonable grounds, decisions made by ministers based on what we've just been through with an exit ban, people not being allowed to leave based on some decision that a health minister made at the federal level, that it was a reasonable measure to stop the pandemic. You know what I mean? Like, and every court challenge seemed to falter because no court was willing to question the reasonableness of that. Yeah. It
is also very early to be discussing a bill like this, isn't it? Given that we haven't really even done a post-mortem on the last couple of years and taken lessons out of that. Do you think this should be deferred at all, Will, or are you happy with this discussion happening now?
Look, I think, I mean, my view and the view that my colleagues also, others have said is we need, the UK has a sunset clause on their law. It's 2 years. In 2 years' time, let's step back and start again, and or learn what we've already learned. I mean, there's a real sense now we're kind of doing this really in a really rushed way. The debate is all over the shop because of all kinds of different factors. It would, I think, be a good thing to have a much more reasoned debate. In 2 years' time, 2.5 years' time, 3 years' time, when we're going to have learned a lot more, and we can step back and say, okay, the way this decision was made was incorrect. How can we, or this kind of decision was disproportionate. I mean, a conversation that needs to be had is how do we understand proportionality? If it's the case that courts are not going to be really powerful checks, then we need to be able to introduce into our political discourse, right, a discussion of proportionality. How can we achieve the same health outcomes but do it in a less impactful way? Those types of conversations I think are important to have. And I just don't think everyone's struggling with this all around the world, of course. So in 2 years' time we'll know a lot more. So it probably is a bit early for this discussion. But I think we'll see what we come up with, but it certainly triggered a lot of discussions, and I think a very helpful discussion. I mean, the discussion in the Legislative Council and the participation of the crossbenchers and what they've said on the media and so forth suggests that that there are real deliberations going on between the government and the crossbench at the moment about these very issues we've been talking about, and that's a really healthy thing.
Okay, William Partlett, Associate Professor at Melbourne Law School, thank you very much for this very, very interesting discussion. Thanks to everyone for joining us on Loose Cannon. Please do get in contact. The email address is loosecannonpod@gmail.com, and also Parnell's Twitter is in the show notes. Would like to hear from people on guests to have on and topics to cover. See you all next time.